Thank you, Chairman and members of the Commission. I appreciate your indulgence in letting me speak a second time. I just wanted to briefly address a few issues. I gave a general overview at the first hearing, and there's one particular issue I want to address in light of the testimony that you just heard, and that has to do with strengthening democracy. The ACLU strongly supports strengthening democracy, but we have a representative democracy, and there's a very big difference. A constitutional convention, by its very nature, first of all, does not allow for the deliberative process that occurs through a legislative process. The Constitutional Convention meets for a few months, they decide something, they vote on it, and that's it. In the legislative process, sometimes things take a lot longer, and sometimes it can be painfully slow, but constitutional issues deserve to be given careful consideration. And it goes through two bodies, not one, and I think that sort of slowing down is extremely important when you're talking about amending our Constitution, because it's not easy to unamend it once it's done. And I think that's a benefit. It's not a disadvantage to have those safeguards in place, which are missing by a constitutional convention. The other aspect that I think is very critical, as much as I also respect the voters and their interest in voting right, in learning about the issues, what we saw happen in 1986, and I'm confident, unfortunately, what we would see happen in 2016, if there were a convention, is the overload that individuals have to deal with. The 1986 convention proposed 25 constitutional amendments. 25. There were so many, they had to be bundled into 14 questions on the ballot. The actual language of the constitutional questions didn't appear on the ballot itself, because obviously that was too much. And we all know the devil is often in the details, whether it's a statute or a constitutional amendment. So voters were faced in the matter of a few months of supposedly learning, understanding, and appreciating what 25 different constitutional amendments really did, what they meant, whether they were good, whether they were bad. And then attached to that, and I think I mentioned this at the first hearing, because of the bundling of the questions, the decisions became even more complex. I believe I mentioned the ACLU itself opposed a ballot question in 1986 that added a free speech clause to our state constitution, because another question in that bundle was the anti-abortion, one of the anti-abortion amendments that Dr. Rodriguez talked about. I don't think that the outcome is necessarily the best or the right way to amend a constitution in that way. We're very concerned that if you have a convention, it's almost inevitable that you will see 25 questions. I mean, that's what they're there for. They're there to propose amendments to the Constitution. So just that process itself is of great concern to us. And then when you add to that fact the concerns you've already heard expressed about the anti-civil rights measures that we believe are likely to come out of it, we are deeply troubled by the process and the whole notion of having a constitutional convention. And for those and many other reasons, we oppose it. I'll be glad to answer any questions.
Are there any questions or comments for Mr. Brown? Ms. Jones?
What do you foresee perhaps in the money that's now available for lobbying and advocacy around these issues, and even for delegate selection, which is very different from what has been available previously? What do you see as, do you see that as a concern in making a constitutional, the election of delegates in the convention itself, and then lobbying for amendments, a different situation than it was previously?
I definitely do. I don't think there's any question that Rhode Island would see a tremendous influx of out-of-state money, whether it's to help in electing delegates or, more importantly, to guide the issues that the convention votes on and ultimately that the voters vote on. I want to give you a staggering figure, and that's $934 million. That is the amount of contributions that were made to ballot measures ballot measure committees across the country in 2012. This is now a big business, and we support the court decisions that say people should have the right under the First Amendment to contribute as much as they want to these types of referenda campaigns. But I think we're kidding ourselves if we think that somehow Rhode Island is going to be immune from that type of out-of-state interest in pushing their own issues, and I definitely think that's something that needs to be put on the table. This will not just be Rhode Islanders deciding these issues. There will be a lot of out-of-state people very interested in trying to guide the decisions as well.
Mr. Frias?
Just a few questions. You brought up the issue of bundling amendments that include different types of topics. Hasn't the General Assembly in the past had amendments that proposed to the public that included bundling of different concepts? For instance, in 1994, they proposed an amendment that downsized the General Assembly but at the same time increased its pay. So in the same sense, for instance, I was a voter at the time. I was kind of torn about the issue because I wanted a smaller size assembly, but didn't want to give them increased pay and free family health care. Would you agree that bundling amendments do occur by the General Assembly?
Not the way they do at a constitutional convention. No, I would not agree with that. I mean, you may be able to choose one or two amendments that the General Assembly has done and parse them into a couple of issues, but again, it's nothing like the 1986 convention, which didn't have two or three. Some had 5 or 6 amendments tied together.
My question was, is it possible? The General
Yes.
Assembly, yes. Thank
Sure.
you. When you indicated that outside that money can influence a constitutional convention or issues raised by a constitutional convention, campaign money. Hasn't campaign money also influenced other types of ballot issues in this state put forward by the General Assembly, for instance, casino?
Yes.
Thank you. Do you agree that it is good, and let me ask you this is a subjective question, have good amendments come out of a constitutional convention in the past?
I'm only familiar with the 1986 convention, and I would say nothing that passed out of the 86 convention was worth it. No.
Not the Ethics Commission amendment?
No, I mean, that's an interesting one. The Ethics Commission amendment was one of the few so-called good government reforms that passed the convention, and here we are 30 years later complaining about that the 1986 convention language we need another convention in order to correct the language that was passed in 1986.
Would you agree that the reason we are trying to change the language in the amendment is due to a Supreme Court decision that was enunciated at the end of the last decade in regards to Senator Irons?
No, I would say it's because of ambiguity in the language that was passed by the 86 convention.
Okay, thank you. It's legal interpretation.
Are there any other questions or comments?